everyone. We are so excited to be here, and I'm happy to welcome you to the ABA section of Civil Rights and Social Justice Civil Rights Bootcamp 2.0. We're thrilled to have you here and for us to have this national virtual conversation and conference where we are bringing together advocates, attorneys, scholars, and community leaders committed to advancing civil rights and social justice. This boot camp was actually designed to be a practical resource for young lawyers, law students, public service attorneys, and advocates from all backgrounds. This is an opportunity to offer real world insight and strategies for navigating today's civil rights challenges, which I think we can all agree is probably needed at this point. So we hope that you'll continue to stay with us throughout the entire program. We have a stellar lineup of panels and speakers across the entire boot camp. This is just one part. So a few housekeeping rules before we begin. We want to make sure that you are submitting your questions actually using the Q&A function. Please do not use the chat because that is the best way for us to be able to monitor questions throughout this session and to address as many as possible. This session, while it is going to be amazing, it is not for CLE credit, but I hope everybody stays because this is still practical and needed at this moment. Today's session is also being live streamed to CRSJ's YouTube channel. So that's going to allow for it to remain available for on-demand viewing shortly after the program concludes. And a recording also is going to be shared with everyone who registered. So please feel free to forward it to any of your colleagues and networks who you think are going to benefit from today's discussion. We also encourage you to use the Zoom events lobby, which is very fancy because you could just go from session to session. And that is going to serve as a central hub for the boot camp for this entire conversation. So you can also view the full event schedule there, schedule and access different session recordings as they may be available, and also to explore the full speaker and sponsor information, connect with other attendees, and find additional bootcamp resources, materials, and announcements. The section on civil rights and social justice regularly provides these type of webinars and resources for legal professionals and advocates nationwide. And we hope that you find these tools supportive in the work that you're doing every single day. And to learn more or to be involved more generally, we would invite for you to actually visit this site. So make sure you write this down, americanbar.org/CRSJ. And also consider joining the ABA in the section on civil rights and social justice. Now let's get started. I first realized that I did not actually introduce myself. I'm your moderator, Abray Connor. I am the director for the Center for Environment and Climate Justice at the NAACP, and I have a history of doing a number of constitutional, social justice, and civil liberties cases over the years, and I am really thrilled because I am joined by today's speakers who are looking at these issues in a number of different capacities. We first have Bruce Warfield Hamilton, who is the director at Tulane Law School's First Amendment Clinic. We have Robert McNamara, who is the deputy litigation director at the Institute for Justice, and Michael Perloff, who is a senior staff attorney at the ACLU of DC. So, what I wanted to try to do is just ask a couple questions that, we have, and I'm sure a lot of people have been thinking about in this moment. And then we're going to turn it to everyone else to also ask their questions. So, because, I know that you all and some folks are thinking about free speech and First Amendment all the time, but there might be some folks who are here and they're learning about this for the first time. So, free speech is such a broad topic, and each of you are going to be covering different parts. So, can you share what your intersection is with free speech and what that looks like for you on a day to day? And I think that, we'll just have everybody quickly answer that question.
Sure. I mean, I'm happy to go first. So I'm Bob McNamara. As you said, I'm the Deputy Director of Litigation at the Institute for Justice. And I think maybe a useful way to think of free speech practice is that like, everything falls into two buckets. There's what you might think of as the traditional free speech practice, where there's a statute that says someone can't say something. You're not allowed to use this word. You're not allowed to publish this. And we do a good bit of that. And the Speaking very broadly, I think the First Amendment doctrines are very strong in protecting things like that. If a city passes an ordinance that says you can't say mean things about the mayor, I think a federal court will enjoin that ordinance and we will all go home patting ourselves on the back about how robust our protections for free speech are. But the other bucket, which we also do a lot of, is what we might think of as First Amendment retaliation, where instead of passing an ordinance that says you can't say mean things about the mayor just sends the police to your house once you say mean things about him and arrests you for something unrelated to your meanness or apparently unrelated. And that is where a lot of this gets complicated. It turns out it's much easier for the mayor to arrest you, have you arrested, fire you, than it is for the mayor to sort of formally announce what the mayor's about to do. And that, I think, has real consequences for how willing people are to engage in political speech. And so, increasingly in recent years, a lot of our First Amendment practice has been more focused on what happens when the mayor arrests you than what happens when the city council drafts an ordinance that sort of more expressly and traditionally says it's illegal to talk.
Thank you so much. I appreciate you like actually breaking it out into two buckets because it makes it easy for like people to kind of understand the breadth. Bruce or Michael, do you want to go next?
Sure, I'll go. I'm Bruce Hamilton. I'm the director of the First Amendment Clinic at Tulane Law School. And, we're a privately funded clinic, and my funder, the Stanton Foundation, really requires that we focus on what are considered core speech issues. So we don't do so much, with like free exercise or freedom of the press, although we do some we do help with press freedom somewhat, but so we every day is different. First Amendment claims manifest in a lot of different ways. We generally have an intake process through which we get complaints of First Amendment violations, and of course, I get referrals and become aware of controversies involving First Amendment violations. A recent example would be like we had some protesters in nearby Pearl River who were arrested because they were carrying signs that said "fuck ICE," and they got arrested and charged with disturbing the peace and other things. Um, but like I said, it shows up in a lot of different ways. I have a professor who was disciplined for social media statements she made about Charlie Kirk. A local blogger who got shut down during the public comment period of a city council meeting. A couple clients who were blocked by a state senator on Twitter, now X. And like a lot of complaints about book challenges in local libraries. So there's a huge variety. It obviously covers a lot, but that's really how I interact with it, is through the complaints that we get.
Thank you. And that is so important. And we love, I mean, extremely sarcastic, broad language that allows for people to somewhat end up in these situations. Yeah. Well, thank you for the work that you're doing. Michael, do you want to go next?
Yeah, thanks so much. So my name is Michael Perl. I'm a senior staff attorney at the ACLU of DC. And a lot of our work touches on the area that Bob alluded to, not the clean cut statute that or policy that is expressly unconstitutional, but government officials taking actions against individuals for their speech. And I think that it's important to think about how broad the scope of retaliation, one of the things about this room is the lights are going to go up and down. So, but one of the things that's important to think about is how broad that bucket really is. So there are cases that Bob can talk about that he's litigated, his team has litigated, where members of the council or the mayor's office have literally just gone up and restricted someone, um, punished someone, tried to impose some sort of criminal penalty against them, arrested them, things like that. But that also extends to some of the cases that Bruce was talking about too. Professors, faculty who are working at public institutions and have their rights infringed or punished for what they say. Government workers who are punished for posting things on social media or affiliating with certain groups. immigrants who join protest movements and find themselves in deportation proceedings. All of this you could think of as various forms of First Amendment retaliation. And sometimes it fits into different doctrinal buckets, which maybe we'll talk about. But what I think it shows is the way in which a lot of the First Amendment action that's happening in our country and in our courts is at this question of what can the government do to you based on your speech, and how much does it matter if the government may purport to have some other, conceivably, arguably, facially reasonable alternative justification. And that's often where a lot of these cases come down and where a lot of our work is.
Thank you so much for that, Michael. And I definitely remember my time when I was at the ACLU of Northern California. It was, to your point, it's like you get everything. And I think that there's a space for free speech for everyone, no matter where you kind of sit in this conversation, to see how you can be a part of this free speech conversation. So we often see the government utilize speech differently, depending on who is in office. And we, I think, have an idea of who is in office now, based on the news and the amount of things that are coming out on a daily basis. And so, how are we seeing free speech conversations show up? In schools, like on campuses, college campuses, as well as K through 12, as well as locally and federally, based on the political climate that we're in now. And then where are we seeing the rollbacks, for particular groups of people, who might be impacted by these decisions?
I can take a stab at it. Um, I can't really speak to high schools and elementary schools, but in colleges and universities, I think the culture is moving toward intolerance of controversial speech. I mean, that's maybe in some ways not really new, but what's considered controversial might be changing. According to the Foundation of for Individual Rights and Expression, their annual survey, students are less likely to tolerate controversial speech than they used to be, or than they were. Students are generally finding it more difficult to talk about issues like the Israeli-Palestinian conflict, abortion, transgender rights, racial inequality, gun control, immigration, gender equality, you name it. And that's just bad for society in general, because we have to be able to, have a respectful public discourse, especially at universities. I think that's partly a reflection of our culture at the moment, the present political, social atmosphere. I mean, for example, the current US administration is engaged in a wide-ranging crackdown on speech that includes targeting the media, student protests, academic institutions around the country. In my opinion, the president has shown a pattern of targeting his perceived opponents and critics for retaliation. That's, really dangerous, because it tends to normalize the sense that dissent is dangerous. And that's bad for our country, because it stifles not just the spread of information, but the expression of speech and ideas. I mean, dissent is patriotic, and it's a fundamental part of what makes this country free. But as for particular groups of people, I'd say immigrants, in particular, have been singled out for First Amendment retaliation. I'm sure Michael and Bob can say more about that. I mean, Mahmoud Khalil is just the most prominent example, but there's so many around the country who've been arrested and held in detention or even deported for expressing disfavored views, including pro-Palestinian views.
I do think it's important to remember too, like this administration certainly has undertaken forms of retaliation that are innovative and new and astonishing. But also what's happening is a universal impulse. Like everyone with political power would like to silence their political opponents. And everyone with political power is going to do their utmost within whatever they perceive the rules to be to silence their political opponents. And so the fight we're having is, in fact, like a universal fight that goes beyond the political moment. As bad as things may seem in the news, that this really is, I think, as Bruce alluded to, like a broader question of kind of maintaining and shoring up the practical legal protections, which are themselves somewhat under assault.
And I'll just add, and I know we're going to talk a little bit more about this later, but I think that one of the things that really is relevant to what both Bob and Bruce are saying is the question of like, what are the foundational principles and values we have as a society for free speech? There are lots of different places you can land at the appropriate way to balance different values with the importance of speech. And I think as a country, we've landed in different spots over our history. And different moments have honestly called for different sorts of balances. And so I think one of the things that you're seeing is this attempt to renegotiate the social norms around speech, personally, culturally, what's acceptable, what's not, politically, how do we enforce those boundaries? What happens when there's backlash? Like all of these things are being reassessed in this moment, and at some level are being reassessed in every moment. And so as much as we're talking about what's happening at the federal level, we have conflicts that are happening at state and local levels where there are questions about, and I think Bruce was talking a little about this, what books can be in school? What rights do parents have to pull their kids from certain classes if they don't like what's being taught? And that's not necessarily that's often more of a free religion issue, but it certainly implicates First Amendment speech values as well, because there's a question about what children should be able to hear. So this is a really contentious issue at all levels of government and all levels of culture. And part of the job, I think, of being an American is trying to find your way and help the country find its way in these difficult battles.
I think that's right. And there's a concept Eugene Volokh likes to talk about that he calls censorship envy, which is that the idea is that when you see someone with political power silencing speech that bothers them, that opposes them, often the impulse is not to say, I'm a principled free speech defender and I'm going to oppose that, but to think, well, what do I have to put up with people being mean to me? And I do think it's important as we see these state, local, and federal controversies that we sort of self-consciously respond to them, not with censorship envy, but with sort of by doubling down on the broader principle of free speech for everybody.
Yeah, I know that we're going to talk a little bit about that because I definitely think that that principle and the absolutist and purist kind of perspective versus the fact that the Constitution is inherently a flawed document, which is why we have so many amendments, and how do we use free speech in the First Amendment in conjunction with many other constitutional protections that we have is definitely a conversation that we need to continue to have, and figuring out, to Michael's point as well, like where are we in this moment, in this country, in this world, is definitely something that we should continue to discuss. And to that point, I think that that really leads into this next question. We are seeing, I think that there are moments that we see upticks in protests around issues that are happening around the country, around the world. And we're seeing that at this moment as well. And we're also seeing a thwarting and a silencing of that speech due to the political climate. Do you notice any differences than, for example, back in 2020, that I would say that that was another time where there was a height of protests that were happening across the country during the George Floyd and Breonna Taylor moment for protests, and what the climate may look like as it relates to like ordinances or things that are happening to protesters, as well as the number of arrests and killings of people who are participating in their protected right in this country. And my quick research shows that the numbers are still kind of high. Maybe the people who are being arrested and killed, that might look different, but that the numbers are still kind of high. So would love to hear kind of like what, from your perspective, you're seeing is the same and like what has changed.
Well, so in many ways, things really haven't changed, right? The relationship and interaction between protesters and law enforcement has always been fraught. And, there's been violence throughout American history between protesters and law enforcement. I mean, highlight the civil rights movement, but the political rhetoric around and the climate around protests has shifted in extremely dangerous and undemocratic ways recently. And this presidential administration in particular has not only sought to suppress protests, but is trying to demonize and dehumanize protesters. And as I said before, dissent is patriotic, and it has a robust history as a deeply held American value: the right to petition the government, the right to criticize the government, to disagree with official policies. But in this climate, government officials are trying to criminalize dissent, and that is deeply wrong and, in my view, un-American. President Trump has consistently framed protests in the United States as a threat to as a threat to be crushed. During the 2020 racial justice demonstrations following the murder of George Floyd, he described protesters as violent and publicly urged law enforcement officers to dominate demonstrators. And then in June 2020, following law enforcement's use of tear gas to forcibly clear peaceful protesters from Lafayette Square, a park across the street from the White House, Trump stood in front of a nearby church for a photo opportunity, declaring himself a law and order president. And more recently, we've seen abusive deployment of military and federal law enforcement to quell protests. I'm talking about Los Angeles, Chicago, and these tactics have really contributed to a climate of fear and confusion that threatens to chill peaceful assembly. And recently, Trump referred to anti-ICE protesters as paid agitators and insurrectionists. So senior officials and prosecutors have also tried to sort of conflate activist groups with criminal conduct. And, you know, someone in the chat asked about the Prairieland convictions. Just last week, for those who don't know, 9 people were convicted by a federal jury in Fort Worth, Texas, for their participation in ICE protests at the Prairieland Detention Center on July 4th. And this was in connection with a non-fatal shooting of a police officer outside the detention center. I don't want to minimize the terrible impact of that kind of violence, but what sets this case apart is that the trial alleged that these 9 people were part of an Antifa organization, and it linked them to domestic terrorism. And one of the charges against them was providing material support to terrorists. Now, of course, you know, this will be appealed, but the fact that prosecutors were successful in arguing that this Antifa cell shared anti-ICE and anti-government beliefs, I mean, it's a clear victory for the Trump administration's sort of campaign to link protest with terroristic activities.
So I think there are a lot of overlap between this moment and 2020, but there are also some important differences, both regarding the nature of the movements that we're seeing, the doctrinal implications of the contests in terms of who the targets are, and also the political effects. So let me try to go through each of those briefly. With respect to the first issue, the nature of the movements, what we're seeing right now is opposition to federal law enforcement. In 2020, what we saw was opposition to local law enforcement. And that is fundamentally distinct because it really creates a very different both doctrinal and political landscape, as I'll talk about in a moment. What we also see right now is that the demands of the movement are different. You know, we've seen such erosion of basic civil rights norms that what a lot of groups are asking for is just like, stop this abusive raids in our city, you know, leave our city alone. In 2020, I think there was a much more visionary sort of set of ideas that were being produced about reforming police. And those were controversial and people have different views about them. But the ideas were something about fundamentally changing an institution. And there was sort of a positive vision of what that might look like. Again, people may have different views about that vision, but there was this broader idea of there needs to be something new. Here, there's much more of a focus on stopping something that is harmful. And so those two distinctions, I think, have fairly significant consequences, both legally and politically. So from a legal standpoint, because the target of these protests are federal law enforcement, the ability to go after those individuals and remediate the violations they've committed is more limited. So you still can get injunctions that will enjoin unconstitutional practices by the federal government. We've seen that happen to some extent around the country, but it's very difficult to get damages. And so it's and getting individual accountability for damages is almost non-existent. So what's happened in response to that has been really interesting. A lot of states have started trying to work through sort of a new, but I think thoughtful legal theory that will empower residents to be able to sue federal officials under state law. And so we've seen legal responses to the state level. And that, I think, informs the political aspect of this, because part of what we're seeing is not a tension between communities and their direct representatives, but between cities and states and those governments and the federal government. And so that then creates more opportunity because there's a much more powerful voice in the room, right? There's the state and city government. So it creates a different opportunity for there to be pushback. And we've seen states file lawsuits. We've seen cities, take legal action. We've seen these new laws passed. So cities are operating and acting within their legal authority, and in some cases pushing the bounds of their legal authority to try to react to what they see as a threat, not just to their residents, but to themselves and their sovereignty. Of course, this is also dangerous, right? Because what it means is that we have a real simmering tension between two sovereigns in our constitutional system. And, that can get dicey at times. So I think that this protest movement is similar in terms of we see opposition to abusive law enforcement tactics, and we see widespread mobilization, and we see lots of violence in response. But there are, I think, important nuances that will shape not only what we're seeing now, but the road to come.
And just to kind of pick up on the doctrinal points Mike was making, to beat a drum I have been beating since long before the current moment, and especially for an audience of young lawyers, if you care about the law of free speech, you have to care about the law of remedies. Because Michael is exactly right that if a protester, or indeed anyone, is confronted by misbehavior from a state or local official, they have redress under Section 1983. The official is protected by qualified immunity, a doctrine which has its own problems that I've written extensively about. But if someone's victimized by a federal employee acting in the scope of their employment, Michael is right that your ability to get any redress, even for their unconstitutional actions, is sharply, wildly limited. It is essentially impossible to get any individual relief. And all claims are channeled into what's called the Federal Tort Claims Act, which I could not explain in the course of the time allotted for this panel if I tried. And so it is a shocking morass that even most lawyers, I think, have never encountered in their practice, of how difficult it is to hold even acknowledged misbehavior from federal officials to account. And that really, I think, it's slightly beyond the scope of this panel, but is the driving force behind a lot of the most important legal controversies we have today.
Yeah, the Bivens action was, already so severely limited, but the Supreme Court in 2022, in a case called Egbert versus Bull, established that individuals generally can't sue federal officers for damages for First Amendment retaliation, which, I mean, the viability of that kind of claim is very much in doubt.
Thank you. And I think that actually, dovetails really nicely into the next question. And first of all, I just want to appreciate, helping the audience to understand, the distinctions and also like the similarities in this moment, because oftentimes, again, this goes to the fact that like when people talk about free speech or they talk about protests and they're like, okay, like everything feels the same, but there are some legal distinctions and things to be considered in this moment, especially when we're trying to figure out ways to meet the moment of what it requires in order to respond to free speech needs at this moment. And Bob, you actually kind of started to talk about this a little bit. But what are we seeing in how employment and labor lawyers are having to review like whistleblowing and other types of cases due to the change in what is considered DEI? And I say considered DEI because that is exactly what I mean. What is considered DEI? Um, can anyone share a little bit more about what you were seeing and how that has impacted free speech conversations for employees as well as employers?
So I am extremely fortunate in that I exclusively sue the government and don't know the first thing about employment law. So I will happily pitch that question to one of my co-panelists who knows what they're talking about.
I mean, I'm not an employment lawyer either. I can talk about it in the, in the public employee context. I mean, just generally, I'd say changes to quote unquote illegal DEI policies have imposed a chilling effect on employee speech. I mean, workers feel uncertain about what they can say regarding social and political topics without risking their jobs. The tension kind of manifests in fear of administrative retaliation for DEI advocacy or participating in DEI programs, and legal uncertainty for the employers, which leads them to restrict speech to avoid liability. So definitions of what constitutes DEI are often vague, and that leads to self-censorship. So workers avoid discussing diversity, social justice, inclusion, and companies have audited or scaled back DEI programs. And they put tighter controls, tighter controls on internal communications and public-facing statements. And employers are just generally mitigating the risk by scaling back their DEI initiatives. And this all sort of creates the choice between advocating for values or protecting your career, which is a really uncomfortable position to be in.
And, sticking with some of the public sector implications here, we've seen cases where the government has fired employees just because they worked on DEI initiatives. And, that is really targeting people for their associations, for their professional relations, and so on, which does raise First Amendment concerns, and we litigated that. And so I think that in that case and many other cases where we've seen action taken against federal employees, the real challenge you face is a very, very complicated remedial scheme that prevents you from going right to court. So you end up having to go to these administrative bodies, which can take a long time. And so this goes back to what Bob was saying. If you want to protect people's First Amendment rights, you've got to look at what protections exist to do that work. And in the context of federal employees, you think back to last winter, where there were so many people getting fired. There were also lots of people facing retaliation. And many of those people really faced very difficult challenges to getting remediation. And the ways they could even get relief were often orthogonal to the ultimate injury that they were talking about. So perhaps they would use a statute that wasn't necessarily about the First Amendment violation, right? But they could use it as a hook to get into court or to get into an administrative body. But ultimately, if you're a federal employee and you're fired for your outside of work speech, which is already limited for government officials, but if it's a First Amendment violation, you should be able to say, government official violated my First Amendment rights. And that is difficult to do, and it's even harder to do in terms of getting relief and damages against federal officials. I mean, really, when you're talking about damages for First Amendment violations by the federal government, outside of the scheme that Congress has enacted for sort of garden variety workplace issues, it's really almost impossible to imagine getting some sort of monetary compensation.
Yeah. And I know that people are not supposed to use the chat, but I will just really briefly say this is just like a very small slither of a conversation that's going to be held next Friday at 12:35 p.m. Eastern, that there's going to be a workplace retaliation conversation, but just bringing it into this conversation around free speech, because I do think that there's like that connection there that oftentimes, people do, to you all's point, they censor themselves or they don't even really know. I saw a comment that there was, that the federal government doesn't even understand what it is. And so again, this goes to this overbroad and vague, concept that then, creates this sense of fear in people. So this administration has created a particular target on policies that impact a range of individuals. And as highlighted earlier, immigrants are a part of that list. And so what is the case law? Is the case law evolving in this area in a way that people need to be aware of?
We've seen a lot of targeting of immigrants over the past year, and that's been one of the groups, if not the group, that's faced the most violation of core rights. In the context of First Amendment issues, obviously, we've seen people facing deportation because of their speech. We've seen, universities punished for their sort of their association with folks who may have more controversial speech, and that's a little orthogonal to immigration, but I think similar impetus. There really are three key issues that I see coming up in the core area of what we're talking about, which is like deportation of people or other sorts of immigration penalties against people because of their speech. The first is, to what extent does the First Amendment protect non-citizens who are in the United States? Now, to me and my view of the case law, there's a really compelling argument that it does, and I think that's the general view. But there are some older cases from the Supreme Court that really predate modern First Amendment doctrine that are somewhat more open on the topic that have yet to be overruled. And so the government has invoked those cases. So far, they have not, to my knowledge, carried the day in any court. But that's sort of out there as a lurking issue that the government is trying to play on. The second issue that comes up is the standard of review that governs immigration actions against people based on speech. So here again, are we talking about our traditional tiers of scrutiny, our traditional general prohibitions on things like viewpoint discrimination? Again, I think that it should operate the same regardless of whether it's a citizen or non-citizen, but there has been some debate, at least in the briefing, about that issue. And I haven't seen the one decision that I'm most familiar with on this. The court ultimately declined to reach the issue and took a more government-friendly view and ultimately ruled against the government even under that approach, right? So we haven't fully seen how that's played out. The final area that is lurking in speech and immigrants' rights is procedural issues. So there are a lot of questions about the proper vehicle to raise a challenge to a person's deportation on speech grounds or a person's confinement on speech grounds. There are a lot of questions about the reviewability based on sort of certain types of government conduct in this domain. And so again, we're seeing these issues percolate through the district courts, move up to the circuits, and a lot of times we're not getting to the meat of the First Amendment issue because we're ending up getting slogged down in some of these procedural issues, which are in often cases are complicated. And that's actually what happened at the Third Circuit with the Mahmoud Khalil case. There was a complicated procedural issue that ultimately resulted in a reversal of a district court opinion. So these to me are the three key issues that are working around in this space. We've seen the administration, I think, move a little bit less forcefully on some of the speech-based retaliatory immigration actions, but I would not rely on the current, perhaps brief lull, which may not even be that big a lull for those who are more closely working in this area, to feel assured that we aren't going to see more of this down the road and to continue working on these types of cases and issues.
Yeah, I mean, I think that the intersection of the First Amendment and immigrant rights is like just frankly deeply unsettled in the case law. The case I keep thinking about in this context is there was a 2012 case called Blumen v. FEC, which was a challenge to an FEC rule that made it illegal for lawful permanent residents to make any independent expenditure in any election. So not just campaign contributions and not just federal elections, but independent expenditures in local elections. And Mr. Blumen's argument was, look, I'm a lawful permanent resident. I live in this city. These city councilors make rules about how I can live my life, and I should have the right to publish a pamphlet that says I think they're jerks. And like I thought that was actually really compelling. He lives there. There's kind of no more fundamental right than the right to print up a pamphlet that says the people running our government are jerks. But the DC Circuit unanimously ruled against him and said that Congress had an interest in preventing essentially people whose, I forget the phrase, it was something like people whose first loyalty may not be to the United States from influencing votes in elections. And that was then unanimously affirmed by the Supreme Court of the United States. And that was the last time I personally was involved in anything that had to do with this direct intersection, but I do recall being kind of astonished by how little shrift the Blumen arguments got, which, query what that tells us for what the current court is going to do with the current cases, but it was not a helpful sign. And I do think, suggest that this area is deeply unsettled. And I think Michael is right that I don't see a lot of recent decisions doing a lot to settle the core doctrinal questions here.
Yeah, the rationalization that has been used, to target immigrants for their speech has been shifting somewhat. But I mean, initially, some of it had to do with the idea that their speech undermined foreign policy, right? Which I don't know. that's a impossible standard, and I don't know why that would apply to immigrants, differently than say any other citizen, as far as their speech having some effect on foreign policy. But it's a really troubling trend line with immigrants in facing this kind of retaliation for political speech or for their views.
Yeah, no, well, thank you for that. And I think that, you know, for all of those who are in law school and just graduating, maybe you will be the ones who will help to come up with innovative ways that we can settle this on the right side of history. So I would be remiss if I did not ask a question about some of the less traditional intersections of free speech and the First Amendment more generally. So I'm someone who litigated free speech cases in a number of different areas, but now I am in the environment and climate justice space. And there has been a documented lack of intersection, from my opinion, as well as, work that I've done for decades, which is linked, in my perspective, to the lack of free speech protections regarding racial justice issues more generally. That we kind of highlighted this a little bit before, but the free speech purist approach has left frontline. And so in the environment and climate justice space, those are the people who are most likely to live near pollution, near environmental hazards. It's left them without protections because case law has often centered the most shocking case, or the case that people have felt at that time was going to, at the end, benefit everyone, regardless of who the plaintiff was. And so a lot of those pivotal cases are devoid of any other constitutional considerations like equal protection. And now with a new wave of issues like AI data centers, there are a number of environment and climate concerns. And we are seeing people's speech silenced across the country when they're showing up at city council meetings, at planning commission meetings, in other spaces. And so, what can we learn from the past about how we can create new models for free speech advocacy that does not leave communities out of the conversations for protections? And one thing I will add, because I saw it in the questions, a lot of folks who are in the environment and climate space have been labeled as domestic terrorists. And I saw that someone was asking a question about the executive order and the guidance from the Trump administration that was put out late last year. So what can we learn about like those past decisions to help us to think about a more inclusive frame for free speech moving forward?
That's a really deep question. I I guess I want to acknowledge like the work of Professor Kimberly Crenshaw, who, for those of you who don't know, pioneered the theory of intersectionality and more or less co-founded the academic framework that we know of as critical race theory. But her work around the concept of, quote, assaultive speech has really influenced my thinking about the First Amendment and racial justice. I mean, she argues, for example, that First Amendment absolutism fails to account for the material harms caused by hate speech. And a powerful idea is that racism or discriminatory speech is not merely expression, but subordination that excludes marginalized groups. And that's a fair critique of the First Amendment. But I don't see, the Supreme Court changing the law on hate speech in my lifetime. So what I would say is it's important to view free speech issues through a racial justice lens, through an environmental justice lens, and acknowledge that free speech principles are built on top of a fundamentally inequitable power structure, which is to say that not everyone has access to equal justice, and your ability to exercise your rights to free expression may depend to a large extent on your power and privilege. So keeping that in mind, I think, makes for better advocacy in and out of the courtroom. But putting aside the question of whether the government can continually restrict or forbid hate speech, we as private individuals, communities, and even companies don't have to tolerate racist or discriminatory rhetoric. So social pressure can be just as effective or more effective than legal redress in some circumstances. It's also a fair point that cancel culture or consequence culture can itself have a chilling effect on public discourse. So tolerance is really paramount. But members of the public are not confined by the First Amendment. So how you react to the speech of others is really a matter of conscience.
Yeah, I think kind of the flip side to that argument is sort of Jeff Stone's point, which is just the history of free speech is that any exception made to the freedom of speech is almost immediately used against politically powerless groups, which I think is fair, right? Like government power is wielded by the people who wield government power, who are definitionally the people with power. And so I think just to stick up for a more absolutist view of the First Amendment, the kind of the best rejoinder to like well-intentioned and like well thought out arguments for exceptions is that just the actual experience of exceptions to free speech protections is that they are almost instantaneously used by the powerful to silence the powerless, or at least to silence the powerless that they find annoying. And I think that is kind of the best argument for the broader view of free speech that sort of the current court seems to advocate, that I certainly would personally endorse. Though I do think, and this is beyond the scope of kind of this discussion, that like a lot of free speech goes back to John Stuart Mill, and I think Bruce is right that like John Stuart Mill's defense of free speech was not entirely about the government. It was about how we should sort of order ourselves internally and how we should be willing to listen to contrary views and listen to things that upset us. And that is, a value that is certainly under assault and something worth preserving.
I think that my thought about, and I'll say this more in my personal capacity, my thoughts about speech have really gone back and forth over the past 8 to 10 years. When I was a law student and I was encountering some of the ideas that Bruce was talking about for the first time, I think I was really thinking more about the ways in which speech can at times silence as much as it can foment discourse. And then I saw the way in which a lot of protest movements on college campuses were addressed over the past couple of years. And I sort of moved in the other direction and said, well, wait a minute, if we don't have a culture of openness to broad-based speech, then what we end up seeing is restrictions and a lot of difficulty defending principles of free inquiry. And so I think where I end up is not too far from where Bruce and Bob are, at least for right now, which is that I don't know that coercive speech reforms, restricting certain speech from the sort of government, I have a lot of concerns about that in any form, and a lot of concerns about it even from private actors. But I think the question is, how are we as citizens, as leaders, as teachers, as parents, like how are we communicating to those who look to us to understand the norms about discourse? Like, are we developing a culture of curiosity and of inquiry that allows people to seek out views and also comport themselves in ways that make it possible for other people to share their ideas? And that to me is really the test. And so in this moment that we're living in, I think the need for that type of deep skepticism against government control of speech, especially what we've seen over the past few years, is very, very warranted. But an equally deep commitment to the culture of inquiry, I think, is important too. And I'll just add that I expect my views and intuitions on this to change many times over my lifetime. There's been a lot of talk about whether the ACLU's views on speech have changed. Have they not? I think that an organization that's committed to free speech should always be reevaluating, should always be assessing what the proper balance is, because the nature of speech, the nature of the society we want, the norms we want to enforce, these are things that will shift, will evolve, not just in terms of our politics, but in terms of what the moment calls for. And so I think it's important for all of us not just to be committed to these values, but also thinking about how best to promote them in our professional and personal lives.
I I agree with everything that was said, and I know that we have a little bit of time for Q&A, and I think that the way that we're doing this is like for people to add questions to the actual Q&A box. And while that's happening, I want to just share my deep appreciation for each of you because conversations around free speech, as I'm sure everyone is recognizing, that we all have, maybe slightly different perspectives around like where we might land, but the ability to have discourse and curiosity, to your point, Michael, I think that most people in this, in this space find that to be incredibly important. And I think for me, where I've landed now, is, who has the ability to actually have that curiosity, right? And if there are people who are left out of the ability to even have that curiosity and to be able to ask those questions, then what needs to be evaluated so that they can be brought into the conversation. And so so if there are questions, I'm assuming that I see a hand raised, but I'm not really sure if folks from this civil rights, social justice side can let me know if what we're doing with, okay, we are not taking hands raised. So if you have a question, please put it in the Q&A because we are not going to do anything with that. Okay, here is a question about that says, I'm wondering if there is any legal intersection between the type of speech that is delivered as a threat of potential impending violence and any First Amendment protections already safely established within prior case law. In other words, in terms of broad First Amendment rights, at what point can individuals or groups feel protected from what can feel like dangerous speech? If anyone wants to try to answer that.
Yeah, so I mean, I guess the history of kind of the regulation of dangerous speech is sort of the same as the history of any other exceptions to speech. Everyone knows the famous Oliver Wendell Holmes line that, the First Amendment doesn't allow you to falsely shout fire in a crowded theater. But what people often forget is that metaphor was deployed in favor of upholding a restriction on distributing pamphlets urging people not to register for the draft. That was the false shout of crowded theater that that was the false shout of fire in a crowded theater that Justice Holmes thought required suppression. And the story there of the latter half of the 20th century and the early 21st is really that exception being radically cabined by the United States Supreme Court. That now, rather than, dangerous speech, speech that incites imminent lawless action, urging a crowd to attack someone is outside the First Amendment. But the court has really done, from my perspective, just tremendous work in paring back a lot of the more dangerous exceptions to the First Amendment and leaving the regulation of what you might think of as dangerous speech to the marketplace of ideas, to shunning, to counter speech, to sort of private society to order what it wants to hear and what it doesn't, rather than entrusting the few people who hold the reins of government to decide what they want to hear and what they don't.
Thank you. We have another question, which I think we can all see it as well. And I'm going to say it out loud because I want to make sure, because there's like two questions in here. So the first part of the question is, did critical race theory not cover the talking points of broader and narrow views of the preservation of the First Amendment right. So that's part one. And the second part of the question is, did it not cover the actual steps to engage different perspectives in discourse? So in sum, the question ends with saying, does the panel agree that the push for critical race theory in education right now is more than a necessity at this moment in US society? And just, for folks who may not be aware of when critical race theory is typically taught, because I think that sometimes people may think that this is like taught in like K through 12. It's typically taught like in higher education. Like I took critical race theory in law school, actually. And so the question is more about, like, does it actually talk about these different, ideas within what is considered critical race theory? And I don't know if anyone wants to answer that. I'm happy to chime in if anyone has, but if Bruce, it seems like you want to answer.
Well, I think Robert had something to say.
Okay,
Well, I
Robert.
mean, honestly, just to the
If you
last
might
question,
comment,
I
right?
think the last thing the country needs is for a guy like me to tell teachers and parents when and to whom they should be teaching what. So I do not have a position I'm going to push. I mean, I don't think any body of thought is a monolith, right? And so, like, yes, there are people within any intellectual movement who have explored ideas kind of to different degrees of depth, and kind of what should be taught to what family and what children is just not my area. I believe very strongly in sticking to my area of expertise, and I do not believe I would make the country better by sitting on this panel and urging anyone to teach anything or not teach anything.
Yeah, I mean, I agree that, the government, that I would leave to teachers, what they decide they should teach in their classrooms. And, I would leave to parents like the job of deciding how to raise their children. And the government should really stay out of deciding like what schools can't offer in their curriculum because of especially when that involves suppression of ideas, which is I think have how the approach has been with respect to critical race theory, because there's a lot of misunderstanding around what that is and what it means. And what we've seen with some of the sort of official elisions of American history is that we're really trying to you know paper over or erase significance part of American history. And I
Oops. I think Bruce froze, at least for me.
Yeah, that was going to be the good part.
you off. Maybe that was off.
Oh,
Oh, he's back.
Bruce, are you there?
I'm here. My internet was
Okay.
bad, so I video off.
Yes. Okay, great. Um, I don't know if you want to finish your thought.
I don't know where you lost me, but I was just gonna. I just think that it's important. Uh, it's important for the government to not necessarily dictate how what goes into an academic curriculum.
Hmm.
So
Yeah.
I'll just add, I think that there's sort of two challenging issues here. One is the question of like, what should our schools teach? And the other question is, what does the law say about who makes those decisions? You know, I think that as a general matter, I'm very, very troubled by the types of restrictions we've seen around the country on teaching things that are potentially um, controversial, but also true about the history of race in America. And I'm also troubled about demands to teach things that are not true about the 2020 election. And so, trends like that, I think, are harmful to the sort of education that we want to see in our society. I also think that sometimes the questions about how we make those decisions are legally tricky, because the way our free speech doctrine works is that it is very, at least the hope is that it is even-handed across um, viewpoints and perspectives. And so if one group can say they want something in or out, the other group can say the same. And so that's where some of these cases about curriculum become trickier, because one group might want there to be an exclusion of critical race theory and an inclusion of, let's say, more religious teaching. And then the next group that's voted in might want the exact opposite, might want there to be lots of critical race theory, but also want to exclude various types of religious ideas from the school, or various types of controversial theories from more right-wing direction from the school, or books that are more controversial, from a right-wing perspective, right? And so these choices about like how communities decide and what the norms are for that, I think presents some tricky legal questions. And so I think it goes back to like, winning an argument for those of us who are committed to a certain idea of what a civic society should look like winning the argument and persuading people to believe that when you get on the school board, you should be committed to a certain set of basic norms that we can, I think, try to find common ground on with respect to truth, with respect to understanding of our past. Winning that argument, I think, is really the question and the challenge. And I'm sure I'm sort of glossing over lots and lots of nuances, but that I think is the real challenge, because the legal issue of who decides remains complicated, and I think in a lot of ways rightly so.
Yeah. I'm going to move to the next question, but I did want to just make sure that it's very clear. Critical race theory is by and large not taught in K through 12. It is taught in higher education, and that's like a different calculus about courses that you opt into taking versus a K through 12 curriculum where that curriculum is set by, if you're at a public school, it's set by the district, it's set by the county, it's set by the state board, right? And so like, so I think that like, and that is unfortunately what has happened with like this administration, is that there's like conflating of like where certain courses are even being taught in the first place. And that is, I think from my perspective, intentional, to lead people to think that having a conversation about the civil rights era is the same thing as having a conversation about critical race theory, and they're not the same. And I think that at a college, if a student opts into a course, they should be able to opt in into taking that course, or at another higher education institution, which is different than like what is also being offered, which is changes to K through 12 curriculum to, for example, get rid of like climate conversations in K through 12 curriculum. And that is like what the other side of what is happening at this moment. So let me go to the questions. I just wanted to like make sure that was super clear for people.
Yeah. And just to clarify, like when I say the government shouldn't be in charge, I mean, in private institutions, the government really has no say in what
Right.
private institutions decide to.
Right. Exactly. So there's yes. So yeah, someone put in the comments like not confusing critical race theory or Black history, which conservatives are doing. Okay, so there's a question that says, is there any advice to give people regarding how to proactively protect themselves against the informal form of retaliation? That is to prevent retaliation before it happens.
That sounds impossible. I mean, I would say like I'm really curious to hear other thoughts on this, but I would say just like being informed. It depends on the context you're talking about. Like if it's employment, know what your employee handbook says, know what your employment laws are in your state. But to try to prevent retaliation before it happens, like, I mean, typically you have some warning that you're in a hot situation, right? Like something's, the boss is paying attention to what you're doing, what you're saying in this environment, in this email or whatever. But generally speaking, I don't know how you're just better armed. You're forewarned is forearmed, and if you can educate yourself, then you're better off.
I mean, honestly, this question makes me sad because the best way to avoid this kind of retaliation is to not criticize people with political power, which is why it is so important that there be some kind of robust damages remedy against people with political power who use it for retaliation, because that's what they want, right? Like, so much of the most controversial First Amendment retaliation stuff coming out of the Trump administration has, like, candidly probably already worked. Uh, the DC Circuit is hearing appeals from the handful of law firms that challenged the retaliatory orders against them. And meanwhile, a huge chunk of law firms knuckled under in order to avoid retaliatory orders. Like, retaliation operates through fear, and it operates through the very natural desire embodied in that question to protect ourselves from retaliation, which is why we need a robust judicial response when we see retaliation, because otherwise it's going to work.
Yeah, I mean, one answer for how do you prevent retaliation for your speech is to not speak, right? But that's not really a viable.
Absolutely. Oh, sorry. I saw, Michael, that you came off mute.
I was just going to add, I mean, I think people should think about their risk to certain types of retaliation. So you're here, you're not a citizen, your risk goes up. You're someone who's a person of color, your risk, I think, goes up. So I think being aware of your situation and thinking about that when you speak is important. But at the same time, we're much poorer as a society if people who are not here as citizens or are people of color don't speak. So every aspect of this goes back to what Bob was saying, which is that, when you start to self-censor, you do exactly what they want. And even when you start to think about all the steps you could take, documenting things, trying to make sure you've got records of statements you could use in a potential lawsuit, you've adopted this burden that makes each act of defiance that much more difficult. So I think that, think about your personal situation, think about the risks you face. But I really do think that it's imperative for those who are in a position where they can afford to speak out, And I think it's also really important to keep in mind that millions of people have marched, have posted things on social media, and have faced no retaliation. So when we talk about this, we should not create the sense that that is the norm. That is still the exception. That's very important.
Well, thank you so much. I think we can answer this last question, and I am seeing that I am at a 4-minute warning right now. So we're going to do rapid response to this. So the last question is, can freedom of speech rights, can, can the First Amendment be used to combat? Um, I am going to take liberties to say this isn't just about anti-critical race theory, but I'd say broader, the silencing of, like, and it says in the quotes Black history, but like things kind of along those lines. Can the First Amendment be used to combat like how Black history has been silenced? And I'm gonna give an example, like, some like from museum exhibits to like renaming of things to course curriculum in K through 12 space and in other spaces, or not recognizing certain important days by this federal government. Like, can the First Amendment be used to help combat the policies that are being put out right now?
Let me try to just go through a few of the doctrinal tangles that brings up. First, we have seen actually some successful cases uh, doing that and challenging curriculum restrictions on the grounds perhaps of students' right to hear. I think those cases are tricky, but there have been some ones that have prevailed. What comes up in this area is that oftentimes you're facing a challenge between a student's right to listen or a student's right to associate or a teacher's right to speak and government's right to control speech. And so those often create challenges. Government usually wins if it's government speech. It has the right to control what happens. Now, there are other challenges that might be more successful. So, you talk about an exhibit that's pulled. If the exhibit is pulled for a discriminatory, intentional discrimination, right, that's hard to prove. But if you could do it, now we're out of the free speech land, we're in equal protection land. Vagueness challenges are something else that we can see. So there are some places where you can go. But I think that there is always the concern in the law that if you are restricting the ability to determine the bounds of, let's say, a public school curriculum from one side, the other side will come back and use that as cultural. So this is, I think, one of the central doctrines and tensions in free speech law and in free speech practice.
So I think that's kind of a great lawyer's answer, but the flip side of that is that the solution to a lot of this is more speech. The great thing you can use the First Amendment doctrine for is nobody can stop you from mailing a box of books to any small town you choose. Nobody can stop you from standing outside a museum with a brochure that tells people what they're not seeing inside. And like that, to me, is the beauty of the doctrine. Can you sue about those things? Michael's right, often not. Can you say your piece? You absolutely can. And that is kind of what the doctrine does for us here.
Okay.
Yeah, I don't have a hot take that adds anything to that.
Thank you all so much. And I think that, question at that last question that we were able to answer is, really highlights, the importance of this moment is that, it is important for us to be looking at this from a free speech lane, but also that intersectional connection and also the organizing, the mobilizing on the ground, work like communities using whatever power that they have, that also is really important, that undergirds, what free speech in the First Amendment is supposed to be about in the first place. And so I just want to thank our panelists one more time for today and for their expertise. If you found today's discussion valuable, we encourage you to share the recording with your networks and to explore other upcoming programs for the section on civil rights and social justice at americanbar.org/CRSJ. And if you are attending the boot camp today, don't go anywhere because our next session will begin shortly and can be accessed directly through the event lobby. Thank you again for being a part of Civil Rights Boot Camp